And with that, I'm going to turn things over to our virtual host and MC of this ICWA Institute, Laura Lee Bentel.
Good morning, and thank you, Ryan. Once again, I'm honored to be with y'all, and I just have to remind every one of our volunteers who are on this virtual ICWA Institute that you are the heart of our program. And I know that the last 2 days we heard a really great presenter from ICWA, David Simmons, and today you're going to hear two great speakers who are going to be doing the Washington ICWA laws, and they have some great things ahead of you. But as again, and in the Indian way, I'm going to open this up and knowing that everything on earth is alive today. Every rock, every plant, every animal, every tree, every bird, we are alive. And what I know today is that each of you, we are all one heart in Kuspu'us. So remember to have an open mind, open ears to the beautiful lessons that you will learn today from Lori Irwin from King County and Casey Looney from Cowlitz County. So with that, I say, I honor you, Paul, and I'm going to pass this over to my two dear friends, Lori and Casey. Thank you.
Good morning, everyone, and welcome to the Heart of ICWA, the ICWA training that we put on by the Washington State Association of Child Advocates. Thank you all for attending. For those of you that have attended the 2 days with David, there will be some duplication, but we'll try to move quickly into Washington law. We're going to start first with a brief video called The Heart of ICWA with Fawn Sharp, who's from Quileute, and if my technology works, we'll all be good. Try it again. Always a blooper at the beginning.
My name's Fawn Sharp. I'm president of the Cornell Indian. When they first came to our home, I started to see right away, this is a really good constellation of kids. My children are third generation foster care, Native American Indian children. Their grandmother grew up as a child in Alaska. She was taken out, placed into a foster home in Oregon. Her daughter ended up in foster care. And then by the time she was 21, she had 4 children, 3 of mine. And that could all be traced back to a federal policy designed to break up Indian children. Welfare Act is designed to keep Indian children whole. When states fail to comply with ICWA, it creates so many problems, not only for the families, but ultimately the children. Our son really started wanting a sibling. He said, "Mom, I want you to have a baby now," as though I could just deliver a sibling for him. My husband and I really started to have a serious conversation about adoption. The social worker called us and had identified 3 Native children. We were told we were the only Native family in the mix. So under ICWA, we should be the family selected. I put a lot of time, energy, effort into a remodel of the house, adding 2 rooms. I bought an SUV. I had a text message from the social worker, "Please call me." She said, "Fawn, I'm so sorry, but the selection committee picked another family." I thought to myself, I'm just going to simply ask for an administrative review just to ensure the Indian Child Welfare Act was complied with. I did a little bit of research, and I came across a GAO report that highlighted the failure of states to implement ICWA the way it was designed and intended. Sure enough, about a month later, we got another letter that said, we did find they failed to follow the Indian Child Welfare Act. However, there's another family that we're going to be placing these children with. We let a good 2 months go by just to sort of, I guess, mourn that loss. In February, of that following year. I received a call from a social worker. She said, "Do you remember the 3 children that you had gone through our process with last year? We placed them in a home and it didn't work out." I just thought, how can this happen? How can this happen? They found that one of the members in the family had a criminal history. If they would have found during the review process that, gee, there's a disqualifying factor, they wouldn't have been even sent to that home. So it was about a 2.5-year process of 2 different appeals and the back and forths and being placed in a home only for 4 months. When they first came to our home, the kids told me that they had gone through some pretty terrible things in that home, and we suspect they had gone through some unspeakable things. It crushes my heart to think that had Oregon followed the Indian Child Welfare Act, the children would not have been placed in a home where those things happened to them. It's going to be with them for the rest of their life. Any child that goes through foster care and they have that disconnection from a nuclear family, it's compounded when that removal is not only from your nuclear family, but your nation, your citizenry. It is in that child's best interest to maintain their identity and who they are as a person. You could just look to the historical trauma that tribes face today. We were taken away from our communities. We were put in boarding schools. Our languages were lost. Our cultures were lost, and our traditions. And you find that young people today, they have that cultural connection. They're becoming stronger. And each generation, we're building and improving and healing from past trauma.
So here we are back. Can you all see the screen? I hope. Casey, can you say yes? Thank you. Casey and I have done this presentation a couple of different times, and I always want to remember and thank Roxanne Finney from DCYF, who has been a very staunch advocate for Native American children and families, and she shared an original version of a PowerPoint that we built on for CASA training. It's been a wonderful process to learn more about ICWA and to share that with everyone. So the roadmap for today, we're going to start off with a little quiz. We'll talk a little bit about the historical context of ICWA, building on what David talked about the last 2 days. We'll talk about the Indian Child Welfare Act in Washington State. We'll have another quiz, a break plan. It's a lot of fun. We'll give you a chance to get up and stretch. Then Casey's going to talk about using the law and the guardian ad litem rules in Washington State as an advocate for Native American children. We'll have a breakout session where we talk about various issues in a scenario. And then we're going to be returning to the large group for a wrap up and more discussion. We appreciate your attention to this. And if you have questions, you can put those in the chat. Hopefully we'll have a little bit of time at the end to address those questions. So if you can look in your chat, you should be able to see a link that Ryan is posting. And I don't think I can see the chat right yet, because I'm on the presenter mode.
Lori, and I'll go ahead and monitor it if you'd like.
Okay, so the questions are in the chat. We're going to go through questions 1 through 4. So if you could all real quick go through those questions. We've got just a couple minutes. Click on the boxes that you think apply, and then we'll come back and have a little discussion. Great. So let's talk about question 1. Who decides if a child is a member of a tribe? Well, you all are A, students, and you correctly identified that the tribe decides. And we'll talk more about why that is that the tribe decides. Question number 2, how many federally recognized tribes are there in Washington? Well, The answer is 29 tribes. We have 29 federally recognized Indian tribes in the state of Washington. And then the next question, how many federally recognized tribes in the United States? The answer is 574 tribes. So in Washington state, there are also tribes that have not yet been federally recognized. In my area, that would be the Duwamish. They're very active. They have tribal lands. They have a tribal longhouse, and they have sought recognition for years. At one time, they were very briefly recognized, and then that was changed by a later administration. And then the next question is, where does ICWA apply? So ICWA, does it apply in district court, tribal court, state court, or federal court? The Indian Child Welfare Act specifically applies in state court only. Tribal court, each court is an independent jurisdiction. They have their own rules and regulations. District court, of course, applies to misdemeanors. ICWA applies in state court and relates specifically to Indian children proceedings, and we'll talk more about that. Okay, thank you for your participation in the quiz. The things that we're hoping that you're going to remember from this presentation, as I just mentioned, the Indian Child Welfare Act applies only in state courts. It's based on political affiliation and sovereignty, nation to nation. The Indian tribes are considered sovereign nations, sovereign entities, and the political membership is a political affiliation. It's not based on ethnicity or race or any other issue other than the political ties between a citizen and their nation. The tribe does decide. They decide on membership, they can decide on placement preferences, and they can decide whether to take jurisdiction of an Indian Child Welfare Act case when an Indian child who is a citizen of their tribe is involved in a state court action. What we're encouraging you all to do a presentation is that every one of you needs to be proactive and to inquire about Native ancestry and to research the files and look deeply into the cases to determine if the children on your dependency cases may have Native American ancestry. So as David mentioned, over the last 2 days, when we're looking at a historical perspective, we have the boarding school era where thousands of Native American children were taken from their families, their tribes, their parents, and forcibly placed in boarding schools with the idea of retraining them for participation in society, in the white mainstream society, teaching trades. Essentially, the children lost their culture, they lost their connections to their families, they lost their stories, their religion, their kinship ties, and it was devastating to both the children and the tribes. In the 1950s, 60s into the late 60s, there was the adoption project where many thousands of Native American children were adopted into non-Native homes. It was an effort by the BIA and others to promote adoption of these children from backward families into more progressive non-Native Indian homes. In 1978, the Congress, the Indian Child Welfare Act, after years of congressional hearings that addressed the situation for the Native American tribes and addressing the disproportionality treatment of these Native children, although it was not called that at the time. So the idea of the Indian Child Welfare Act is to protect the best interests of Indian children and to promote the stability and security of Indian tribes and families. The testimony that is involved in the Indian Child Welfare Act is powerful. If you ever have a chance to go back and review that or to review the written proceedings, it is very powerful. So one of the findings that was made by by Congress states there is no resource that is more vital to the continued existence and integrity of Indian tribes than their children. If you think of any community, any family, children are the future. Children are the potential that every family has, that every community has, and to lose that potential is to lose existence. So the Indian Child Welfare Act here, Public Law 95-608 from 1978, addressed issues related to children being removed, as you saw in the video with Fawn. And if you go forward with the NICWA videos that follow from Fawn, there are a number of reports of personal experiences and familial experiences with what happened when children were removed from Native American homes prior to the Indian Child Welfare Act. If we're looking about 25 to 35% of children being removed, 1 in 4 children, 1 in 5 children being removed from their families, devastating to those communities, destroying families, destroying the tribes, destroying their future. So if we look at disproportionality again, this map kind of shows the distribution of this issue across the United States. If you notice, Washington has a great deal of disproportionality. That means that the rates of Native American children going into foster care at stages of the foster care system are much greater than their representation in the general population. In this chart, it's pointed at 4 times as many Native American children being in the dependency system than non-Native children. There's a report, a disproportionality report in Washington State that you can find just by Googling Washington State disproportionality in child welfare, come up with a report that's a number of years old now, but it does not appear that the situation has improved in any way. Across the state of Washington, you'll also notice if you follow up on reports that there's disproportionality in other communities, particularly the Hispanic community in terms of representation in the child welfare system. But by far the greatest disproportionality is the number of Native American children, because in Washington State, the population of Native American children is quite small, but in the foster care system, it's a significant population. Under the Indian Child Welfare Act, states, and we'll talk some more about a recent case called In Re ZJG, came out in September of 2020, that from our Supreme Court, that has made some significant changes to practice in the dependency area. But what states are really supposed to do is, if they have any idea that there's a potential Native American heritage, they're supposed to notify the tribes immediately. There's some real specific processes for doing that. There is a list of tribal representatives that is kept by the BIA. And in Washington State, there's a NAIR unit, NAIR unit, and you'll hear more from them, that their responsibility is specifically to notify tribes. So once a tribe gets notification, they of course have to process that, which means they get notification either electronically or by letter or both, or sometimes it's a phone call, and they need to look in their roles and go through the genealogy charts and try to figure out if there is a connection, and that can take time. And once the tribe has determined that a child eligible for membership, or that their parents are eligible for membership, then the tribe has to decide what they intend to do. Try to intervene in the process. That means they'd be a full party, and sometimes they'll have attorneys that represent them in the dependency case. They can also seek to have the case transferred to tribal jurisdiction. On the west side over here, we have a number of tribes that actually have tribal courts that address dependency cases. And if it's a tribal member that is involved in a dependency that's filed in state court, the tribe can ask to have that transferred back to tribal court. And many times that'll happen. So when the state identifies that there's this tribal connection, the state needs to immediately make active efforts to provide services to the Indian family before they make the placement recommendation and after placement occurs. So active efforts are required before that child's ever removed from the parent's care, unless there's an emergency removal. And those active efforts have to continue after placement happens. It doesn't matter if the placement is with a relative or in a foster home, but if there's an out-of-home placement, they have to make active efforts. So we're going to talk about placement preferences for Indian children because there's a real specific list of preferences. The tribes can also designate a different preference order. When we're talking about long-term planning or just establishing dependency, the state also has to meet a higher legal standard to establish dependency or to terminate parental rights. And all along the way, there needs to be a qualified expert witness to testify about the child's situation and to recommend findings to the court that this dependency is needed. So in Washington state, I mentioned 29 tribes, and we can kind of see a map here with the different tribes out on the coast. We have the Quinault with quite a large land area, the Makah up at the very far northwest corner, a number of tribes that with smaller areas all along here in the Puget Sound area, and then up to Lummi and Nooksack in the northwest. Over in the east side, we have Colville and Spokane. Spokane and Colville have, Colville has a large area and is a confederation of tribes. The Spokane tribe has a large land area and a large population, and then Kalispell over here. The Yakima people are in the Yakima area and have a large area here and a large population as well. In addition to children that may come from local tribes, in Washington state, we also in the metropolitan areas on the west side, like Seattle and Tacoma and Everett, and then along in through here, there were a number of Indian people that were relocated from more central United States areas out to the coast. And because of that, there are many, many tribes that are represented and that we see in court out here along the coast, as well as the Alaskan tribes. One thing to remember, the Indian Child Welfare Act applies to federally recognized tribes. That means if you are working with a family that is from Canada, that's a Canadian band, the federal Indian Child Welfare Act does not apply. So here we go. Washington State Indian Child Welfare Act, RCW 1338. In 2011, finally, the Washington State legislature enacted the Indian Child Welfare Act for Washington. We often refer to it as ICWA. This applies to dependency and termination of parental rights proceedings, to dependency guardianships, like if you've heard of RGAPs, it applies to that. It also applies to the new minor guardianship law that goes into effect this year, and it also applies to adoption proceedings. That means in all of these proceedings, there needs to be notice to the tribes, and there need to be active efforts applied. The intent of the legislature is reflected in the preamble to the legislation. It emphasizes the necessity to protect tribal relations and the best interests of Indian children. There's a definition of best interests of Indian children. The state needs to commit to placement that reflects the tribal values and the child's culture. Despite this legislative intent, I think that you'll find when you're working on these Indian Child Welfare Act cases that there is a lack of Indian foster homes and culturally appropriate services for Indian children and family. It is a work in progress and something to advocate for in all of your cases. So you'll hear some more from the NAIR unit when they talk about verifying Indian status. I talked about the inquiry to the tribe and notice to the BIA. We also, because we share a border with Canada, we also have Canadian bands, and I would encourage all of you, if you're working with a case that involves a Canadian band child, that you contact that band and inquire about benefits and connections, cultural connections that can be made with that band for that child. Um, you probably heard of the Blackfeet in Montana. Well, the Blackfoot are a Canadian band, and they share common ancestry and are only separated because of that border, that artificial border. But the Canadian band, the Blackfoot, also have tribal activities, tribal and cultural heritage that could be shared with the children, and you should consider that. Throughout the case, the child's advocate should be inquiring into the child's Native American status. So if you look at RCW 1334-105, that specifically is one of the things that the CASA child advocate or guardian ad litem are to do. So I mentioned in re ZJG. So this was a really important decision from the Supreme Court in September of 2020. We hold that a trial court has reason to know that a child is an Indian child when a participant in the proceeding indicates that child has tribal heritage. I know that Ryan's going to share this PowerPoint presentation. I have the link right here so you can look up that report. You can also just type in ZJG and Google will find it for you. This is a really detailed decision by the Supreme Court. It goes over the history of ICWA, talks in detail about the reasons behind the Indian Child Welfare Act and the Washington State Indian Child Welfare Act, and provides a lot of background information that is really helpful. So what is the impact of this? Well, I can just say that in my own practice that there's been a pretty substantial impact. If anyone has a reason to know the child may be an Indian child, the child should be treated as an ICWA case. That means that every case that you have should be scrutinized. You need to look back through the files and again, inquire with the people that are active on that case, the relatives, extended family, and the parents about potential Native American heritage. There are increasing numbers of children that are identified as Indian children. Parents say, well, yeah, maybe my great aunt or my great grandfather or somebody, they were tribal. Well, that has to be checked into. I think what the result of this is going to be is that we're going to find out that we have missed a number of children that potentially have political affiliation with tribes that we didn't even know about. As David talked about in the last 2 days, there's a tremendous pressure on Native people to fit in, to go along, to get along, and to lose their Native identity so that they could survive in the general world. With the adoptions that went on, the number of children that were removed from their families, there are a lot of people out there who don't necessarily know who their people were, where they came from. What you need to be prepared for, though, is that there can be delays associated with these inquiries to the tribe. So just last week, we were talking about a case with the Blackfeet in Montana and learned that there's like one person to process inquiries and they get 50 to 100 inquiries about Native status a day. That's in a small community, Browning, Montana, that they have limited resources, and yet they're being asked to determine whether a child is a Native child so many times a day, and they're overwhelmed. So be patient. You can certainly contact the tribe and inquire periodically about how the inquiry is going, whether they've determined if the child is a Native child. All along through this process, once that child is identified as an Indian child, there needs to be active efforts, and that is something that you can prod the department to provide. And active efforts, more than just making referrals and handing people a piece of paper. Active efforts are defined in the Washington Indian Child Welfare Act and in federal regs, but they involve a great deal of participation by the social worker in working with the family to address their issues, whether it's housing or substance abuse or domestic violence or mental health issues, parenting issues. there needs to be a real concerted effort to provide those services and walk along with the parents as they are encouraged to access and participate. One of the things I think is really positive is if a child is identified as potentially an Indian child, that opens up a whole host of opportunities for this child in terms of cultural activities, expanding their identity and their access to relatives and extended family, and looks more in a more detailed way into potential connections that could be really positive for those children. And you should think of what culturally appropriate services might be available for the children in your area. So when we talk about placement, so the Indian Child Welfare Act has a big impact on placement decisions. One of the things that I'm going to ask you about a little bit later, and hopefully you'll pay attention, is that we have to talk about who gets to decide what the placement priorities are. Well, placement priorities are listed out in the Indian Child Welfare Act and the Washington Indian Child Welfare Act, but tribes can also make a decision. Tribes as sovereign governments can decide, maybe for them, if a child can't be with a parent, then the mother's brother is the next option, or maybe it's always the grandparents are the next option. Tribes can also designate and license their own foster homes and specify that sort of placement. When you're thinking about your cases, in addition to inquiring with the tribe about what their placement priorities are, you also need to think about starting with the family. The family is the priority first, and actually the family should be the priority in all of our cases, looking at relatives and those connections that the child will have throughout his or her life. So parent, the aunts, uncles, grandparents, brothers, sisters, extended family, cousins, researching all of those people to find potential placement options for the child. I know that one of our GALs has worked very hard to research relatives and is finding more and more people, because she's mining the file, as they say, but also she's looking at potential connections that might be there because the children may be Indian. Tribal foster homes, as I mentioned before, there just aren't enough tribal foster homes to support the children that we have in out-of-home placement. They can be licensed by the state, by a private agency, or by the tribe. They can also be licensed, as I said, by a non-Indian agency, like a private agency, sometimes Amara in our area. DCYF, of course, is the state. Catholic Community Services, Lutheran Community Services, other agencies that may license children. Or it could be some other tribal approved institution. The very last choice should be a non-native licensed foster home. And unfortunately, that may be what our options are. If that is the case as a CASA, then I would encourage you to support that placement by encouraging cultural connections for that placement, so that the child or tribal traditions and be connected with tribal members in the community. So adoption placement preferences follow along with the foster care placement. First, it would be a member of the child's extended family, a member of the child's own tribe or a similar tribe, then any other tribe, and the very last placement would be a placement in a non-native foster home. Some tribes have addressed this by having customary adoptions or approvals of placements. I know that some tribes in Washington state have a broader view of this and embrace non-tribal members as placements and take them inside their arms and fold them into their tribal community so that the children remain in the community even though they're not in a tribal member's home. Tribal involvement in dependency proceedings can take many different forms. If you have a case that involves a tribe that's active, they could either be participating fully in all the meetings. Some of the tribes have resources that only allow them to participate on a peripheral basis, meaning that they may be able to call in for hearings and they're happy to receive reports, but they are not able to participate in all the meetings and activities that go on cases. Certainly, because we have so many Zoom meetings now, it does make it easier, I think, for tribes that are a long ways away to participate and stay in touch, but still many of them don't have resources. The tribes that do take jurisdiction, sometimes they will only take jurisdiction after dependency is established. And so as a child advocate, the work that you do to establish dependency and to work on placement really lays the foundation for the tribe to be able to take the case back into their own tribal court with a well-established plan going forward. If the child resides on tribal lands, the tribe will have jurisdiction. And there's really not a good basis to object to jurisdiction unless a parent objects to that. Absent some really good reason, if the tribe requests to transfer jurisdiction, it's going to happen. You've heard of qualified expert witnesses. A qualified expert witness is required for placement out of the home and for termination. That person should be designated by the tribe, or it could be a person who has expertise in Indian child welfare actions. It cannot be the social worker supervisor. I know that that was an issue, a question that came up with David's presentation, but it's very clear in the statute that the qualified expert witness cannot be the supervisor of the assigned social worker. It could be someone from the same office. The practice in my county is for another supervisor or the area administrator to be that qualified expert witness. It's a big job because they need to review the file and be pretty familiar with the issues involved in the case in order to make that decision. The qualified expert's responsibility is a very important one because it provides that perspective on the case to the court. Casey's going to talk some more about this, but I would encourage you to work with the tribal representatives on your case. Make sure your reports get to them. A simple thing is asking your office to email out a copy of your report to the tribal representative. When you go to court or when you're at a meeting, making sure that you have the tribal representative's phone number and encourage that person to be called. Make sure that they're on the Zoom calls. Remind the parties and the court for every hearing that the tribe needs to be included. If the tribe has intervened, they're a full party, they have to be present if you're going forward with a hearing. And if they're not available, it needs to be rescheduled because they are a party, just like a parent, just like the state, just like the child advocate is a party. You can't go forward unless the tribe is there. I want to encourage you to view the tribes as a wonderful resource for the child and family. They are the experts on the traditions, the culture, the expectations for that child's family, for that child, and providing each child with a healthy identity is an important part of the work that we do. Hopefully, we're involved with a child's life for a very short period of time, but if we can set them up with these connections, it can make a lifetime difference. What we're looking for is making that positive impact on the child's life early on. So Ryan, we're going to go to the next quiz. So can you put that up in chat, and can we see if maybe folks have already answered all the questions?
Yes, ma'am. Give me just one moment. So we're going to be looking at part 2 of this quiz. For those of you that have already answered, we'll go ahead and look at the answers.
Okay, so here you all correctly answered that how the tribes can be involved in the dependency case, all of the above. They can attend court, they can monitor the case, they can participate in meetings, they can consult, and they can also intervene. So I'm sorry, but what is the placement preference? I don't have the question right now to know what the fourth one is. But I believe the fourth one is a placement with family, if I remember correctly. And you're absolutely right that placement with family is the first choice. The final choice would, of course, be placement in licensed foster care. And then we can look at the child advocate's responsibility with ICWA. Yes, it is your responsibility to advocate for the best interest of the Native American child. And it's also your responsibility to report on the child's membership in any band or tribe. In your report, hopefully there's a section that you can report whether they have Native American heritage, and then also whether ICWA applies, because of course they could have Native American heritage, but not have that all important citizenship that would make the ICWA apply. To promote the best interests of Indian child, I really congratulate all of you, because it's really all of the above. I think one of our jobs in many of our cases, whether they're ICWA or not, is really to push the agency to provide services, to make those connections, to provide visitation, to be the squeaky wheel to get the attention to the case. And then, which of the following are a good cause to not follow ICWA placement preferences? We didn't really talk about good cause. Oops. Which are the good cause not to follow? A child's attachment to foster parents is not a basis under ICWA or WICWA to not follow ICWA placement. A parent's objection could be a reason to not follow ICWA, but is not likely to be a reason. Primarily the reason to not follow ICWA placement preference, it would be extraordinary needs of the child, or a specific objection based on the child's needs. So the lack of services near the ICWA placement, not necessarily a reason. There needs to be work done to provide those resources. Economic advantages in the foster home, not a good reason, because we know that there have been so many impacts on Native American families that is not a reason to avoid a relative placement. So Ryan, I need you to let me come back. Thank you. So now what we're going to do is I'm going to share screen. Hang on just a second. And we're going to take a real quick break, and then we're going to come back. I'm a couple minutes behind. This is a warm up.
It's cool to warm up.
It's not working,
You know
Lori.
that old-fashioned phrase, don't try this at home? Please do try this at home.
I think you clicked the wrong window.
Sorry, hang on. You guys are all really patient with me, and I appreciate that.
Make sure you get up
Working
and
now?
around.
Yes.
Thank you so much. And my apologies. Here we go.
It's cool to warm up. You know that old-fashioned phrase, don't try this at home? Please do try this at home. Ready? Begin. Hip rotations. 2, 3, 4. Make sure you get up and around. Change. Now we were bringing it out and bringing it in. Good job. Now we will be bringing our legs up to our chest. Ready? Begin. Hold it. Down. Hold it. Down. Modified version at home would be okay to hold onto a table or chair. Get balance. Looking good. Good job, you guys. Way to go. Now we'll be doing butt kicks in place. They will look like this.
I hope
Begin.
you all are taking the advantage of this time to stand up and stretch a little bit.
10 more seconds. Looking good, you guys. 5, 4.
What I think is funny, y'all,
3,
is that I could see you all
2,
doing this because we've
1.
done this in person at the conference
Woo!
before. So
Now we begin high knees.
it's pretty great, you
In
guys.
3, 2, 1, go. Bring those knees up. Looking good, little James. Way to go, James. All ages can do it. 5 more seconds. Push yourself. You're doing good. 5, 4, 3, 2, 1. Breathe. In your nose, out your mouth. Now we're ready to dance. Let's powwow sweat.
So thank you all for that little brief intermission. I hope you got to stretch a little bit. So what we're going to talk about now, and I'm going to turn the mic over to Casey. Normally we'd be standing next to each other, nudging each other about stuff. We're going to talk about using the law and guardian ad litem rules. Thank you.
Thank you, Lori. Hi, everyone. I'm Casey Looney. I work with the Cowles County Child Advocates Program in Cowles County, and we'll be going through some ways that you can use all of this law that you've been hearing about today to better advocate for Alaska Native and Native American children on your cases. So as Lori talked about earlier, that reason to know in re ZJG, the court has to inquire of parents and all parties if they know of any type of tribal affiliation which could qualify the child as an Indian child under ICWA. So if anyone answers yes, that includes you as the child advocate. That means there is a reason to know, and ICWA applies from that moment forward, and the child gets those protections of ICWA, unless we later find out that those tribes have determined that the child does not qualify. The second piece of that inquiry, and then the state has to make a determination based on the tribe's the tribe's response, that the child no longer falls under ICWA's protections. So as an advocate, as Lori mentioned earlier, there's probably going to be some longer wait times because of this new Supreme Court decision. So you can ask for an early review to check in on that status. It doesn't mean, unfortunately, that it will go any faster, but it's important to keep that before the court so that they understand that that's something that we need to pay attention to. And also remember, this is an ongoing inquiry. There may not be any reason to know early on in the case, but if we continue to ask all those people involved in those children's lives, we may find a reason to know, and it's our duty to inform the court that we now have a reason to know that ICWA can apply to that child or to that sibling group. So we also have the RCW 1334 chapter, which just applies to dependencies in general. There are duties that are laid out for guardians ad litem, and every volunteer advocate in Washington State is a guardian ad litem, so those rules apply to you as well. So one of those most important ones is reporting to the court about that legal status. So if we find information from a family member, if grandma suddenly comes up with, oh, here's my enrollment card that we didn't know about 3 weeks ago or 3 months ago, it's our duty to inform the court we have that information. So we also want to make sure that we are advocating for the Native child's best interest. So the Indian child's best interest means that we are helping ensure that those practices that are being put in place by the department and by the child welfare system as a whole are following the applicable law and also accomplishing the following things. So this is kind of a long one, but we'll get through it together. So first is protecting the safety, well-being, development, and stability of the Indian child. We want to protect the well-being of every child, but we have to keep those special protections in mind for our Native children. We want to prevent the unnecessary out-of-home placement. As Lori said before, that active efforts applies to that before removal piece of the case as well, unless there's an emergency need for a child to be removed. So we want to also acknowledge the right of the Indian tribes to maintain their integrity and promote stability and security for those children and their families. And also we want to recognize that the value of the Indian child and having that connection is very important. So these two together, C and D, really boil down to we need to be making sure we're advocating for the child's right and the tribe's right to have a connection with each other. That's hugely important for any of our children who are Native. Whether they actually are eligible to enroll or not, it's best practice to make sure that they have that connection. And then the last one is that underneath the state ICWA or WICWA, that we are prioritizing placement appropriately. It's very easy to just put a child into a 30-day temporary placement and into a foster home after that. For the state, it's easier than trying to find someone who falls under those priority placements. So where we can really make a difference is helping do that legwork and finding those people who would fall under those higher priority placements, like relatives or other tribal homes who could care for those children. So in addition to those RCWs, we have the Guardian Ad Litem rules, and Guardian Ad Litem Rule 2 is sort of our roadmap for what to do or not to do as a Guardian Ad Litem advocate. So Section G says that we have to make a reasonable effort to contact all parties involved in a case. So at the beginning of a case, a tribe may or may not be a party to the case. If they are a party to the case, it's pretty easy. You have to be in contact with them, make those reasonable efforts. But best practice under ICWA is whether or not the tribe has become a legal party by legally intervening, is that we are being in contact with them. So if we're in contact with them, we can make sure that we're looking for these different types of connections for our kiddos. So they can give tribal perspective for the family and the child. They can help make sure those kids are in contact with local relatives. And if there are no local relatives, there may be tribal elders that can help share tribal teachings and wisdom with the children. They can provide educational materials that you can then pass on to the family and the child, especially if their tribe is not local. That can be really important and helpful. And they can also share information about what tribal events are happening locally, or like us right now, they may be having something online that they could participate in from home. So under another section of Guardian Ad Litem Rule 2, Section O, we have the ability to request an early review to talk about a specific issue. So one of the easiest ways that we can make sure that those things are being brought up is to ask for that early review. It can happen at a regular review. We can just say, hey, can we have a review in 60 days to talk about this again? So we can look at whether that notice has been provided to all tribes, because in my experience, they're not always all thought of at the beginning. They may come up with new family members who have different tribes that they are related to potentially, and so there may be additional tribes to look into. Whether we've received replies from all of those tribes, again, that might be a little bit longer wait, and whether that placement is a preferred placement. So that's a question we want to keep asking as well. We don't want to just have a child go into a licensed foster home and say, well, they're safe there, they're stable there, let's just not worry about whether or not that's an ICWA preferred placement. And any other concerns that might fall under ICWA, for example, the tribe's level of involvement, if they want to change that. We can talk about what they think about permanency options if it's later on in a case. There's a lot of different things we can ask for those reviews to talk about. Okay, what else can we do? We can ask for a shared planning meeting. So you don't have to wait for the social worker to say, hey, let's all get together and talk about this. You can bring it up and say, hey, I think we need to talk about this, and let's get the group together and do it. We can also ask for a LICWAC staffing, which you've heard us mention it multiple times over the last couple of days, but tomorrow you'll get a much more in-depth understanding of what LICWAC does. But for now, to just remember that the LICWAC Council will talk about kids where tribal enrollment hasn't been decided yet, or they can also continue to have LICWAC staffings once a child's enrolled if the tribe asks for that to happen. All right, so those are just some tips on what you can do as far as being an advocate and making sure that the law is being followed. So now what we're going to do is share a link that will give you a scenario. It'll be a Google document, and I'm going to put that in the chat right now. So there's a link to a Google document that you should all be able to download right now, and then Ryan is going to break you up into breakout rooms for us. We're going to try and do your responses a little differently than we originally planned, so my slide's a little outdated here. So there's no need to pick a spokesperson, because we're going to see if we can get you all to answer us as a group. So we're going to put you into breakout rooms for about 10 minutes. You'll read through that scenario. At the end, there's a list of 5 questions that you can talk about in your group. Then we'll come back together and we'll talk about those questions and answers.
6-year-old Stuart's teacher discovers bruises on his back and contacts the Spokane DCYF office. A CPS investigator meets with Stuart and requests permission from law enforcement to take Stuart to the hospital for an exam. Permission is granted, and an X-ray reveals a small fracture in his right ankle. The CPS investigator determines that Stuart is at imminent risk of physical harm and retains custody of him. In addition, CPS also removes Stuart's sisters, Laura, age 4, and Emma, age 2, from the care of their parents, Mona and David. Mona's son from a previous relationship, Alex, age 9, is also removed from the home. Alex's biological father is a registered member of the Beecher Bay First Nation, a Canadian tribe. All 4 children are placed into emergency foster care. When questioned by CPS, David admitted to hitting Stuart and knocking him to the floor when he refused to do his homework. Mona knew David had knocked Stuart down, but was afraid to take him to the doctor, fearing all her children might be taken away. At the initial shelter care, the court finds that all 4 children are at risk of imminent physical harm and rules that the children were appropriately placed into emergency foster care. When asked by the judge about any tribal affiliation, Mona states she has none. David tells the court his maternal grandmother was enrolled with the Ketchikan Indian community, but he is not sure if he's enrolled. After the shelter care hearing, Mona and David tell the CPS investigator they want to have children placed with a family friend, Ellen, who is a member of the Coeur d'Alene tribe and lives in Pullman, Washington. Ellen has an established relationship with all 4 children. Mona and David request a contested fact-finding hearing. At that hearing, the state court finds the children dependent and orders services for Mona and David, which include parenting classes for both parents, an 18-week anger management program for David, and a protective parenting class for Mona. The Ketchikan Indian community does not file documents to legally intervene in the dependency case because they are still investigating whether David is enrolled or eligible to enroll. However, they do ask to be kept informed as the case progresses. After the dependency is established, the children remained in the foster home where they were placed upon removal from the parents' care. A volunteer advocate is assigned after the fact-finding hearing. The volunteer reviews case discovery and then speaks with the CFWS caseworker. The caseworker tells the volunteer they have never heard of Ellen, and as a result, she has not been contacted. The CFWS caseworker also states that the parents are not appropriately engaging in their court-ordered services. The volunteer advocate then speaks with Mona and David and asks David if he has been able to confirm his enrollment with the Ketchikan Indian community. He says he has gotten a copy of his enrollment card but is having trouble reaching the CFWS caseworker to give it to them. Ketchikan Indian community has confirmed his 3 children are eligible to enroll as well. Mona then tells the volunteer advocate that she spoke with her mother the day before and discovered that her mother is an enrolled member of the Coeur d'Alene tribe based in Idaho. Mona does not know if she is eligible to enroll. David says he is uncomfortable with the teaching style of their current parenting class because it is in conflict with his tribal beliefs. He is asked to take a different class. His anger management class starts next week. Each of the children, when spoken with separately, expressed to the volunteer advocate their desire to return home to their parents. Alex, Stuart, and Laura all tell the volunteer that if they can't go home right now, they want to stay with their auntie Ellen. Questions based on the scenario we just heard. Number 1. Does the state court have reason to know under In Re ZJG that ICWA applies to any of the children? Number 2. Which, if any, of the children are Indian children? Which, if any, of the children are Indian under ICWA? Which ones? And how do you know? Number 3. Does the active effort standard apply to the ongoing case? If so, is this standard being met? Number 4. Did the state follow the hierarchy under ICWA regarding placement of the children? And finally, number 5, is the volunteer advocate responsible under ICWA, a GALR, or other requirement to keep the Ketchikan Indian community informed as they have requested? If so, how can the volunteer advocate meet that responsibility?
Okay.
So mainly I just wanted to show this because the Healing Heart Totem is from my hometown in Craig, Alaska, and I was part of the raising ceremony for it. So just a little plug for my hometown in Southeast Alaska. All right, I hope everyone had a good discussion, and we're going to try something a little different than putting things in the chat. Ryan is going to be my person here to help me out with getting you all unmuted. So what we're going to do is I'm going to read the question. Then I'm going to count to 3. And after I say 3, you're all just going to call out your answer to this question. So we're going to give it a try and see how it goes. All right, question 1. Does the state have a reason to know under In Re ZJG that ICWA applies to any of the children? 1, 2, 3.
Yes.
I heard yeses. You guys are good. Okay, so yes, that's the short answer. So at the initial shelter care hearing, David indicated that he has a connection to a federally recognized Indian tribe, and that's the Ketchikan Indian community. So in order for reason to know to be triggered, he does not have to be enrolled at the time he states he's affiliated to the tribe or potentially affiliated.
Doesn't even have to be enrolled.
So once that standard applies, and the children fall under protection of the ICWA. So there's a 2-step process that we mentioned kind of quickly earlier, that once we have that reason to know, in order for that reason to know to be dissolved in the court's eyes, the tribes have to make the determination that the children are not eligible, and then the state court has to make a determination on the record that ICWA no longer applies. So because that's new, we're expecting there may be some debate as to what type of tribal documentation the court needs to see in order for them to say accurately that ICWA no longer applies. So tomorrow in my county, we're having our first hearing on this, so we'll see how it goes. We don't know how that's going to look for us. So there may be even potentially a witness needing to come in to testify. We're not sure. So just be aware that that could make things a little different. All right, question 2. We're gonna do the first part and then we'll do the second part. So we'll stay on this slide. Everyone will give me their answers to both questions and then we'll go to the next slide with the answer. So first part, which, if any, of the children are Indian children? So shout out your answers. We got 1, 2, 3.
All of them.
All of them.
All of them. Okay, so now the second one, which, if any, of the children are Indian children under ICWA? And the which ones and how do you know? We'll just have you answer that silently. So which of the children are Indian children under ICWA?
All of them.
All of them.
All of them.
All of them. Okay. Let's see. Let's go to our answer. Oh, some of it's all popping up randomly. So yes, all of the children are Indian children. They all have tribal connections and Native history and ancestry. With the current information we have right now, ICWA applies to Stuart, Laura, and Emma because they are the children of an enrolled member of the Ketchikan Indian community and are eligible to enroll. So with the information we're given right at the end where mom kind of was like, oh, my mom told me she's enrolled, no one else knows that yet. So according to the court, only those 3 kids fall under ICWA. Alex doesn't yet. So at this time, he's not the child of an enrolled member of a recognized tribe and is not enrolled himself. And as Lori mentioned earlier, because he has First Nation heritage, doesn't mean he falls under ICWA because that Canadian tribe's not federally recognized by the US government. So far, you guys are doing an excellent job. All right, question 3. Does the active effort standard apply to the ongoing case? Give me your answer. 1, 2, 3.
Yes.
Yes.
Okay, answer this next piece in your head. If so, is it being met? That's a little trickier. All right, let's go on to the yes, it applies to the ongoing case because we already have definitely those 3 kids with dad. They fall under ICWA without any question. And it's possible that ICWA could apply to Alex in the future because mom's not sure about whether or not she can enroll and whether or not Alex might be eligible for the Coeur d'Alene tribe. So the department still has to show those active efforts to both parents. That was a question we had earlier. ICWA applies to the whole case. Once the child falls under ICWA, the whole family, as far as that child's biological parents, also qualify. So it doesn't have to be a Native parent or a parent who is Native under ICWA to have those active efforts apply to them. So both parents need that. And right now it's a little unclear on whether or not the caseworker is meeting that standard, but keep in mind that active efforts means supporting the family and finding those culturally appropriate services and helping them engage in those services. Because you remember
And returning phone calls.
So keeping in contact, because we had David's like, I'm trying to get them my enrollment card, but they're not answering me. And he was also mentioning that he's feeling uncomfortable with the teaching style of his class and he's asked for a different one. So that's something that the social worker is responsible for providing active efforts to help resolve and to make sure that they're following ICWA. We can help follow up on that as well. So number 4, did the state follow the hierarchy preference under ICWA regarding placement of the children? Answer in 1, 2, 3.
No.
No.
Unequivocally no, right? You guys did a great job. So CPS investigator and then also the CFWS caseworker did not contact this family member, this family friend who's also a tribal member and has a relationship with all the kids. They pretty much fall under every category of a preferred placement you can find. To find out if this is a safe placement. That doesn't mean they have to send the kids there, but they have to check into that placement. And so, you know, if a placement is requested by the parents, is a member of the child's tribe or another tribe, that's preferred over foster care whenever possible. And this person is also a suitable other person placement just under our general dependency rules because they have an established relationship with all of the kids. All right, we're on to our last question. I know you guys are sad to be at the last question. You've been having so much fun that I know you're getting a little teary-eyed, but it's gonna be okay. We're gonna be fine. All right, so is the volunteer advocate responsible under ICWA, a guardian ad litem rule or other requirement to keep the Ketchikan Indian community informed as they have requested? 1, 2, 3.
Yes.
Yes.
Yes. Answer that second part in your head. How can we do that? Think about it for a second. All right, let's go on to the answer. I got muted. I'm back. So yes, a child's tribal representative should receive a copy of the advocate's report for any review hearing once they've asked to be kept informed about what's happening with the case. So it's a courtesy when they're just asking to be informed. Like in our scenario, they haven't intervened, but it is required under Guardian Ad Litem Rule 2, Section I, if the tribe has legally intervened because they're now a party and we have to make sure that we're giving our report to them. Keep in mind, you should always be in contact with the representative of the child's tribe throughout the case for that multitude of reasons that we've already talked about. There's so many benefits that the tribe can help provide that it's in that child's best interest to maintain a good rapport and good contact. So also think about the fact that Guardian Ad Litem Rule 2, Section G, that's a rule that we're required to follow, also says we have to make those reasonable efforts to be in contact with the parties, which includes our tribe, and those best practices. Just making sure that you are doing everything you can to make sure that that child is having their heritage respected, that ICWA is being followed as appropriately as we can make it for every kid that falls under its protections. Because social workers are overworked, even when they're required under law to do specific things. I have seen it, unfortunately, where it doesn't happen, and we've had to kind of nudge them, unfortunately, repeatedly. So your ability as an advocate, as a volunteer, to give that focus to those kids is so hugely important under ICWA because there needs to be somebody paying attention to those pieces. So we'll kind of bring you back to what we started at the beginning of some important takeaway points. So thinking about ICWA applies only in state court. So if there's tribal jurisdiction and the tribes take that jurisdiction, we're no longer involved. ICWA is not a factor. ICWA applies based on that political affiliation with the tribe. It's not a race-based law. It has been brought up in the past that it might be, but at this point under the law, it is not. It is a sovereign to sovereign agreement between the US government and the tribal governments. The tribe, and only the tribe, decides membership, whether or not to change those placement preferences that are laid out in ICWA, and whether they want to take jurisdiction, intervene, or just to be kept informed about what's happening as the case progresses. And remember, with that jurisdiction and legal intervention, that can change at any point in the case, even after a termination for parental rights has been filed. So at any time, the tribe can choose to intervene. They don't have to do it at the beginning. And as advocates, be proactive. Ask about that ancestry ongoing. Do what you can to connect those kids to their culture. It's hugely important. One question I get asked a lot when I provide these types of trainings is, well, if they've never been connected to their tribe, why does it matter? It matters hugely. I grew up in Southeast Alaska, and I have family who are Alaskan Native, and having them not be a part of that because they were relocated or because they never met that side of their family is a huge piece of them that's missing. So keep in mind that we're giving them back something if they didn't have it. We're not keeping something in the dark that they never knew about, we're giving them another piece of themselves.
Casey, can I just expand upon that too? Is that,
Of course.
and I think David also talked about it, because I know that with my own family histories, that a child who is Native and wasn't brought up in that Native family, there's a hole missing in their heart. I remember the first time I danced, it was like my whole life just became full circle. So it's really important that we keep children in touch with their culture, because you may see them just enliven and brighten up and become their whole being that they were meant to be, because they found that home that they had been missing and didn't know they were missing.
Absolutely.
Thanks, Casey.
Thank you for sharing that, Laura. Okay, that's all for our presentation. The slides have been sent out through chat. Lori's contact information and my contact information are on both of those, as well as some resources that we used while we were putting this slideshow together. So if you have further questions, absolutely reach out to us.
We also have
Go ahead, Lori.
So I was just going to say, Casey, if people have some questions and they want to pose those on chat, we have a few minutes that we can address those.
Yep.
I'm not.
I was just going to say that.
Yeah, it's like, you know, when we kind of walk through this, we thought it was going to take a lot longer than it did, and we appreciate your being our test group, I guess, for this presentation. But please add, if you have any questions you want to add on chat, things that have come up over the last 3 presentations, the 2 by David, and then the 1 by us, please let us know and we'll answer that, because we have a few more minutes.
And I know I saw some questions earlier that were kind of popping up in the corner of my eye that I didn't have a chance to answer while I was speaking. So if you had a question that hasn't been answered earlier, please ask it again.
Well, here's a question from Judy early on. It says, does ICWA apply to non-Native child who is adopted by a Native family? Sure, because that Native child has been adopted and is a member of that family. They would also have all of the rights and responsibilities of a birth child. So I would say, yes, ICWA would apply to that child, because it's not a genetic connection, it's the political connection.
Right, and again, the tribe decides who can be enrolled. My family in Alaska, I have non-Native families who have been adopted into Tlingit Haida tribe. So absolutely, once they have that political affiliation and they're a tribal member, their ethnic heritage is not a factor in whether ICWA applies.
Right. And Laura earlier asked a question about whether active efforts applies to the non-Native parent of a Native American child. And again, as Casey mentioned, the ICWA applies to the entire family, both parents, if a child is an Indian child under ICWA and WICWA.
Okay, I see a question about blood quantum level. There's really not a lot to say on that, unfortunately. It's just with the tribal determination. So every tribe has their own way of determining who's eligible to enroll. Some of those are based on blood quantum. Some of those are based on very different criteria that they evaluate. It was an artificial thing put in place by the Bureau of Indian Affairs long ago that is used by tribes, but that determination is fully up to the tribe. And once they've decided if a child is eligible to enroll or they enroll that child, they are going to fall under the protections of ICWA regardless. So.
Right. So, and the other thing to remember is, because it's a political determination of citizenship, that determination can change. The governing group, where the tribal council or the elders, however they make the laws for the particular tribe, can change the enrollment criteria for that tribe by a ruling. So when a child may not have been able to enroll because at one point there may have been a requirement that they have like 25% Indian blood, and they changed that to just that you have to have an elder that was on the roll from 1950s, then you need to keep checking back because the citizenship status could change, much like the enrollment process for being a citizen in the United States or getting a visa or something can change.
Right. And I think that's really important when it comes to if a child is a descendant of a tribe and you get that letter from the tribe, it is really important to make sure that wherever that child is at, that is always continued to look into for that particular tribe. Because as Lori said, enrollment can change at any time.
Right.
Thanks.
When that tribe's ability to expand their enrollment comes along, they can change that at any point. That's something that the Cowlitz tribe is actually looking into right now, that they have finally gotten tribal lands and now have more revenue, that they may be able to expand their enrollment and change their enrollment criteria. I see another question. Is it appropriate? As I start to read it, another question popped up and now I have to go back up and find it again. Is it appropriate for a CASA to help with the enrollment verification process? Not quite sure what part of the process
the answer,
you
Lord
mean,
Casey, the answer is no to that, because it's the parents have to follow through. We can help them get the information, the department can help them, but it truly is the parent who needs to follow through.
Yes,
well,
and so
I have a story for that too. Go ahead, Casey.
I was just say, and the only thing that we've been able to do in my county is it's not really helping with the verification process, but helping follow up on whether or not the information has been given to the correct people. We've had a case where the grandparent is trying to help with enrollment and they can't get a copy of the child's birth certificate that's supposed to be given by the social worker, those types of things, where we can help say, hey, let's have a meeting, let's talk about what's holding this up.
Right. I have a case where the CASA found a grandfather who was enrolled and is working to get paternity established for the child's mother so that she can be enrolled, so that the child can be enrolled. So it's not necessarily the verification, but boy, I've had CASAs be really active on trying to put those pieces together so the family can do the enrollment. And like Casey said, getting the birth certificates and getting the forms, sending the forms out. I've had CASAs help fill out the forms and go over that with grandparents and parents so that they can get that done. Here's another question with a parent that claims Native American ancestry with 7 tribes, but they all said didn't acknowledge the claim. So because of the relocation and in my area, we have situations where it appears that the child is completely Native American, but because of the different enrollment criteria for the different tribes, the child does not fit under ICWA and is not a citizen of any of the tribes. It's a very sad thing. There are some tribes that may take in a person who is not enrollable in other tribes, but it's very difficult, and it kind of breaks my heart about that stuff. Laura Lee, do you have any perspective on that? Hope you're on mute still.
You got muted again.
I was actually answering another question, so I really didn't hear the
Oh, this is the question about the father that has Native American ancestry at 7 tribes didn't acknowledge the claim, and the issue about children may have ancestry with multiple tribes, but they don't really fit under any tribe for membership or citizenship. You're on mute again.
Yeah, I think that's trying to tell me something, eh? I think if there is any type of question about American Indian ancestry, I think personally, I will treat that child as an Indian child. I would try personally to do some research to see what tribes information I can obtain for those children. That's really a huge question and has many journeys that we can go down. So you can always contact me and or Lori and Casey regarding, really detailed questions.
Right. Yeah, and with that question where the parent claims heritage in different tribes, but the children don't fall under ICWA, we're still in that best practice piece where we want to keep contact with those tribes and get those children whatever connection to that heritage that we can. Whether or not ICWA applies, we want to make sure that we're doing what we can to find out what their tribal practices are. Is there an elder who can share information? Do they have a website? A lot of websites out there for tribes now are amazing. They have stories, they have language learning. There's so much that you can find in our digital world to help kids stay connected and find a connection to their culture.
Yes, because it's much more larger than just taking to powwows.
Right.
Right.
So,
especially if you have a kid who's Alaska Native, we don't have powwows. We have potlatches.
Exactly.
That's right.
Exactly.
So Maria asked about the responsibility of being in touch with the tribe, if that applies equally to the assigned social worker and the child advocate. Well, the social worker, they're the ones that have to make the active efforts. They've got to demonstrate they made active efforts. So the social worker absolutely needs to be in contact with the tribal representative. I think it's best practice for the CASA or the guardian ad litem or the child advocate to be in contact with the tribe, because that way you'll have a better understanding of what the tribal practices are, what resources there might be, family connections, cultural connections, so that you can make that happen for the child. But if we go to trial, the social worker is the one that's going to have to show that they've made active efforts.
Absolutely. And I would say that the responsibility is higher on them to make sure that they are documenting everything. But we need to have an equal responsibility in making sure we're keeping that connection for our kids and building that rapport with the tribe so that we can help advocate for what they need.
So Greg asked, what about if neither parent is present? I think we've all had cases like that where unfortunately neither parent is participating in the case. The tribe still needs to be notified. There need to be active efforts made to reach out and to find the parents. Often the parents they're not really not there. They're just not participating. So the social worker needs to continue to make those active efforts to contact the parents and offer them services. And the child needs to be provided culturally appropriate services, be in an appropriate placement, all of those things. And so with the Alaskan tribes, I've been working with Alaska tribes. The Tlingit Haida tribes have a very well-developed tribal representative program. And if you can figure out who your tribal representative is, they'll be a wonderful resource and something that you should work on developing. You need to be in all of your contact with tribal representatives, you need to be patient and respectful that they're one person and they may have many, many children that they're responsible for, and they have limited access. In the Alaskan tribe, sometimes they're extremely affected by weather, and it makes a huge difference in whether or not they have internet access and electricity, because power goes out. Casey can talk about that, but you need to be really patient and just provide a consistent response to the tribes and be supportive of their participation.
Absolutely. And one other thing that you can do as an advocate is, if you know possibly which tribes are involved, is to contact their tribal government. Honestly, I have a case where we had one child who was enrollable. The other, we don't have paternity yet. Tlingit Haida tribes were definitely indicated by the parent as having ancestry, but we weren't sure which specific tribe. So in Alaska, things are a little different because we like to do things different in Alaska. And every village is its own tribe. So we were trying to narrow it down from broader Tlingit Haida, which covers all of Southeast Alaska, to the specific native village that these children may have come from. And one of them happened to be my hometown. So I just called up the Craig Tribal Association and said, hey, do we have record of this family? So you can contact those groups yourself and try and help facilitate that and say, if you have record, here's the social worker's information, please contact them so that we can move this forward. So we can do that piece as well.
And I think it's important when you do that, you say and the verbiage that I would use is that we have one of your children.
Definitely.
Yes.
Yes. And I say, we have a child who may be one of the Craig tribal members.
Yes.
We're not sure, but do you have record of this family?
Yep.
And never go straight to business when you're talking with tribes.
Thank you, Kate.
That is not how they run. You got to get in there. You got to establish a relationship and some rapport with them first, because if you just come in there and say, I need answers, you're not going to get a very warm response. Thank
you, Casey.
Yes. And you will find out that your tribal representatives are wonderful and fun people to know. And it's good to develop those relationships on all your cases. I like Mike's comment about being a pain in the bum. It's like, yeah, sometimes as child advocates, isn't that the truth? I mean, but we're polite about it and respectful about it, and we keep asking. And mainly, my joy in life is to be a pain in the bum to DCYF, but we just need to keep asking questions and till we get action.
Yes. Yes. And I do have to say, social workers really are overworked, but I think
Absolutely.
there's a way of making sure your voice is heard for your children that you have on your caseload in that respectable way. So, and Lori, I love you, and I could see you being that pain. I like to say we're a thorn in their side. But, for me, I have to respect them for the work that they do as well.
Absolutely. Absolutely. Any other questions that anybody has that's burning inside that they want to ask?
Did we miss anyone? Because sometimes the chat scrolls by really quickly and we may have missed a question that was asked. If your question was up on chat and we didn't see it, can you repost?
Oh, and here's a wonderful post about tribe attending a LICWAC at the tribal longhouse.
Yes.
That is a wonderful thing.
Yes, it is. Yes, and we always have food at those meetings, no matter what.
So Laura's worked with me for a long time, and as Casey said, you need to realize that you just don't come in with your checklist on these cases, and it can be a challenge for those of us that are really checklist driven.
Lori, you're great.
So we have just had a really nice time talking to you all. And when do you get done with a presentation? 10 minutes ahead of time. We are, which slide are you asking for, Casey?
Oh, sorry, it was slides. Someone asked for the presentation again, so I was asking Ryan if you could just post it one more time.
Yeah. So I think that the PowerPoint's being shared, and I wanted to point out to you at the end, I have some resources. Casey added some resources. I encourage you to follow up with looking at fun things like Powwow Sweat, and then also look at the ICWA website, and I think there are a few other websites that are on there. Read INRAE ZJG. It is really interesting. And then Supreme Court Justice Raquel Montoya Lewis is speaking on Friday. She was the author of that decision. I reread it again this morning, and I am so impressed with the depth of knowledge, the understanding and explanation that is provided in that decision for why the court made that decision. I think it really is helpful to have that decision process laid out to everybody.
And I think on that same line, Laura, she's the first American Indian Supreme Court Justice for the state of Washington. So she has lived as an Indian woman and has worked all her life to be where she's at today to continue the voice And I'm very grateful that we're able to have her at the end of this ICWA Institute. And if there's no more questions, you let me know and we can wrap this up. And I want to say thank you, Casey. Thank you, Lori. You always do such a beautiful job in your presentation. And as I've told you in all our meetings, this is going to be the best ICWA Institute we've had. Plus being it on Zoom and being able to reach so many more advocates and the department, the social workers, and just everybody. It just enlivens my heart. So thank you, thank you. And tomorrow, please join us again because we're going to have NAIR, which is the Native American Inquiry Request, as well as LICWAC, which is the Local Indian Child Welfare Advisory Committee. Two really great people who have a lot of knowledge in this, and you don't want to miss that. So Casey, Lori, you're very close to my heart. So thank you. And I honor you for what you do.
Thank you, Laura.
Thank
Thank you
you.
everyone for being here. Have a wonderful rest of your day, and we'll see you here tomorrow morning at 10.
And maybe we'll see you next year in person.
Oh, that would be great.
Wouldn't that be fun? Or maybe even later this year. Ooh, ah.
Ooh. Bye, everyone.
All right. See you.